what does it mean to maintain a minimal standard of living? What does it mean, my circumstances are unlikely to improve? Or what does it mean? Have I made a good faith effort to repay my student loans? Does that apply a good faith effort this past year, this past 10 years? What does that exactly mean? So essentially, you have to show that if I pay my student loans, I'm going to be under the poverty level and that my current circumstances aren't going to improve. Very difficult test, right? So, let's say you had, someone who had a workers' comp injury and they weren't able to work and their income really dropped and they weren't able to maintain a minimal standard of living, and we would go try to get rid of student loans, and the court would say, well, can you show me that it's unlikely that your circumstances not going to improve in the future? Hi, it's attorney Jamie Miller, and thank you for joining us for another edition of the Miller Law Chronicles podcast. Today, we're going to talk about a really exciting topic that is going to impact many of you, and it is the dischargeability of student loans in bankruptcy. It's been a while since I last broadcast here. I've been really busy in my personal life and in my with my law firm, and so I haven't had a chance to really get back with you and talk about important topics of the day. But I'm excited to be back here today. It's a beautiful spring day here in Wisconsin, and looking forward to a wonderful summer. But one of our goals coming out of winter and spring is to really push and help people get rid of student loans in bankruptcy. And there's always been this myth that you can't discharge student loans in bankruptcy. Most people believe student loans are immune from bankruptcy, but that thought is outdated. There's been some things that have changed since November of 2022, and there is now, thankfully, a path forward to get rid of student loans. To give you a little history on dischargeability of student loans, there was a time, probably 20, 25 years ago, where we could get rid of student loans if they were older than 8 years and they've been in repayment. But I think that changed in about 2008 when something called the Brunner test came along. So prior to November of 2022, if someone filed bankruptcy and had federal student loans, and we're only talking about federal student loans, you could only get rid of federal student loans in bankruptcy if you passed the 1987 case called the Brunner test. So the Brunner test put really strict rules on how we can get rid of student loans in bankruptcy. So when you file a bankruptcy, let's say you file a Chapter 7 or you file a Chapter 13, student loans are exempt from discharge. So in order to get rid of a student loan in bankruptcy, you have to file another lawsuit in the bankruptcy court requesting that your student loans be discharged. So if I file a bankruptcy and I list $20,000 in federal student loans, those student loans would not be discharged unless I took the extra step of filing a lawsuit in the bankruptcy court naming my student loan company requesting that my student loan debts be discharged. So that action that we would file in the bankruptcy court would have, if I was trying to get rid of your student loans prior to November of 2022, would require me to pass three-step tests. Number one, I'm asking to get rid of my student loans because I can no longer maintain a minimal standard of living, that my circumstances are unlikely to improve in the future, and I've made some sort of good faith effort to repay that debt. And the judges interpreted these factors very strictly. And as you can tell, these are very subjective. What does it mean to maintain a minimal standard of living? What does it mean, my circumstances are unlikely to improve? Or what does it mean? Have I made a good faith effort to repay my student loans? Does that apply a good faith effort this past year, this past 10 years? What does that exactly mean? So essentially, you have to show that if I pay my student loans, I'm going to be under the poverty level and that my current circumstances aren't going to improve. Very difficult test, right? So, let's say you had, someone who had a workers' comp injury and they weren't able to work and their income really dropped and they weren't able to maintain a minimal standard of living, and we would go try to get rid of student loans, and the court would say, well, can you show me that it's unlikely that your circumstances not going to improve in the future? And again, really hard. Judges ruled these very strictly. But thankfully, the Biden administration in 2022 came out, and the Department of Justice and the Department of Education issued guidance to simplify the student loan process through bankruptcy. What they did is they basically said, we have to go through the same process. We have to file an adversary in the bankruptcy court, and then we submit something that's called an attestation form. The attestation form is a form that asks several different questions and allows us to tell the bankruptcy court what your situation is. But the important thing is it moves away from those subjective questions in Brunner. Can you maintain a minimal standard of living? Are your circumstances unlikely to improve? Have you made a good faith effort? To more of an objective standard, where if you come into our office and we fill out the attestation form and we look at the objective questions and your situation, we're going to be able to give you a better idea of whether or not we're going to be able to get rid of those student loans. So we fill out this attestation form, and it has all kinds of personal and demographic information. So we need to know your name, your age, marital status, your number of dependents, education and employment history, health or disability status, your income information, your gross income. What's the source of your income? Employment, disability, Social Security, alimony, child support. We're going to look at your current monthly expenses, your rent, your mortgage, your utilities, transportation, food, medical costs, childcare costs. We're going to look at your assets. How much money do you have in your bank account? Your vehicles, your home equity loans, all those types of things. And then we're going to look at your student loan history. Who's your loan servicer? What was your original balance? What's your current balance? How much is your monthly payment? What's your repayment history? And have you applied for forgiveness previously? So we're going to go through all of those things, and we're going to know, looking at your name, looking at your age, looking at your marital status, your number of dependents. We're going to look at your income. We're going to look at your expenses, and we're going to be able to make an objective evaluation and review of your case. And we're going to be able to tell you, listen, you need to file bankruptcy because to get your student loans discharged, we have to fundamentally file bankruptcy for you so we can get in front of the court and ask them to discharge your student loans. But instead of that subjective Brunner test where, it's kind of a flip of a coin, when we do the attestation form and we know that you meet certain elements of satisfying the discharge of your student loans, we can say with more certainty that we're going to be able to get rid of your student loans and we're going to encourage you to head in that direction. So there's other good faith indicators also. So in addition to those factual things, name, address, income, expenses, you know, they're going to look at, have you tried to communicate with your loan servicers? Have you made attempts to enroll in different payment plans? Is there a hardship? Or are there any other steps that you've taken to resolve the debt. And then once we submit this form, the Department of Justice is going to review your attestation form and make a recommendation whether or not those loans should be fully discharged, partially discharged, or restructured. So what happens is instead of us going to the court, spending a ton of money preparing your case, going to trial, and having the judge decide, it's a very adversarial. So we have the Department of Justice, the lawyer from the Department of Justice, and we have you and us representing you. The new process is you file the bankruptcy, we file the attestation form with the Department of Justice. The Department of Justice and our office will go back and forth and discuss the elements needed for you to discharge your student loans. And then the Department of Justice is going to make a recommendation, which the courts, in my experience so far, will always accept. So if the DOJ makes a recommendation that your student loans will be discharged, we'll submit an order to the court, and the court will then sign off on the order discharging your student loans. Takes time, takes effort, but we're here to put this together. And we have lots of experience now in the last 2 years, almost 3 years of being able to do this. We've had over 30 clients who've had their student loans discharged. The percentage of cases that we take on and discharge those student loans is really high. So essentially, who's a candidate for this? Anyone who has over $15,000 of federal student loans. Now, this doesn't include private student loans. So if you have over $15,000 in federal student loans, regardless of your situation, I wouldn't, go online and kind of try to be your own lawyer and search things. I would highly encourage you, if you have federal student loans of over $15,000, give us a call at Miller and Miller. We're happy to do a full review for you and then make the determination of whether or not this makes sense. Now, keep in mind, you may have 50,000 or 60,000 in federal student loans and other debts that aren't bothering you at all, but you still will need to file the bankruptcy, and that's a big consideration. Do you want to file the bankruptcy and to discharge this debt? Are you willing to take that step to file and try to get rid of your student loan? So, how does this work? Well, you would contact our office. We would set up a free consultation. We'll review the attestation form with you, and we're going to make a recommendation to file a Chapter 7 or a Chapter 13. We'll get the case filed. We'll then file that adversary proceeding, so that extra lawsuit in the bankruptcy court to discharge the student loans. We'll complete the attestation form. We'll work with you to get that put together. We submit it to the Department of Justice. We'll go back and forth in conversation with the Department of Justice, and then we'll wait their recommendation. The court will then review the recommendation and will sign off on the order discharging the student loan. This process is now very structured, it's very fair, and it's very achievable. And most of our clients who are qualifying for the discharge of student loans never imagined that their student loans can be eliminated. And now they can. So, who can qualify? Borrowers that have a lower or fixed income, older adults who are near retirement, people with chronic illness or disability, single parents or caregivers, those who tried to pay but just can't keep up. Even if you've defaulted or if you've missed payments, you may still qualify. It's about your overall effort and your financial ability to pay back the student loans. So even if you're making 60, 70, $100,000, is it possible to discharge student loans? Potentially. It's worth having that conversation. But if you have a lower or fixed income, If you have a lot of dependents, a lot of children, you're taking care of older adults, you have a chronic illness or disability, you're a single parent, or you're just having a hard time keeping up, make sure you have that important conversation with us. So give us a call, go to our website at millerlaw.com or bankruptcylaw.com, millermiller.com, or milwaukeebankruptcy.com. Just search Miller and Miller and you will find us. There's a toggle at the top that will allow you to schedule an appointment. But we look forward to hearing from you and giving you that free consultation to see if you're going to be able to discharge your student loans in bankruptcy. I really appreciate you listening to this Miller Law Chronicles podcast. We're happy to chat with you, but if you really liked the podcast, please like us, subscribe to us, go to YouTube, go to Spotify. You'll find us, wherever you will, find your podcast. Tell your friends about us. And again, there is a path to getting rid of your student loans in bankruptcy, and I look forward to chatting with you soon. Take care.